live.
Good evening and welcome to this week's FedSoc study break. My name is Tiffany Duncan and I'm the president of the Baylor University School of Law chapter of the Federalist Society. I wanted to thank you all for your time and spending your time being here with us this evening. This event is put on in conjunction with the Student Division of the Federalist Society, as well as the Free Speech and Election Law Practice Group. The Federalist Society's 15 practice groups are organized by substantive areas of law. Each practice group is led by a chairman and executive committee comprised of top lawyers from across the country. They meet each month to organize in-person events, webinars, publications, and the panels for the Federalist Society's flagship event, the National Lawyers Convention. You can learn more about the practice groups at fedsoc.org/practice groups. Tonight, we are pleased to welcome the chairman of the executive committee of the Federalist Society's Free Speech and Election Law Practice Group, Professor Michael Dimino. He is a professor at the Widener University Commonwealth Law School, where he teaches constitutional law, election law, First Amendment, and other subjects. He is the lead author of the casebook Voting Rights and Election Law, and also of Understanding of Election Law and Voting Rights. Thank you, Professor Dimino, for sharing your time with us this evening.
Thanks very much, Tiffany, and thanks to the Federalist Society. Thanks to everybody who joined on the call. It's really nice to be here.
Yes, thank you for sharing your time with us. Since we're on the subject of practice groups, just real quick, would you mind sharing a little bit about the work of the Free Speech and Election Law Practice Group and how you came to be involved?
Sure, of course. It's been my honor to be part of the Free Speech and Election Law Practice Group's executive committee. I've been on close to 10 years now, and it has enabled me to interact with some of those top flight lawyers that you mentioned who care deeply about the issues of free speech law and of election law. It's especially nice for me that the Federalist Society has combined those two subject areas into one practice group. There is, of course, a lot of overlap. A lot of election law is related to free speech. Campaign finance is one obvious area where the two, it's an election law kind of regulatory area that has free speech implications. And a lot of other kinds of limitations on political speech impact elections. And those of us who just gone through a whole campaign season for today's midterm elections are well aware of how the law shapes what candidates say, how they present themselves, how newspapers, the freedom of newspapers to discuss candidates, and social media, the Constitution's freedom to engage in debate is fundamental to the American system, not just because we care about having the freedom of conscience and the freedom to investigate areas that we find interesting and to seek out information and have free thoughts and that. But the Constitution's protection of free speech is also fundamental because it enables self-government. It allows us to discuss issues, to make good choices at the ballot box. And so there is a kind of fundamental connection between free speech and election law that the Federalist Society has recognized in putting this practice group in the center of both of those areas.
That's great. You briefly talked about your involvement in the practice group. How has your experience and your involvement with the practice group enhanced your legal career? And what might a law student expect from involvement in a practice group?
I've gotten two benefits out of it, and I think that students who are considering becoming members of or active in practice groups can expect to get those same two benefits. Number one, I've gotten connections with people that I wouldn't otherwise have come to know. I've benefited greatly by being able to interact with people who are now friends of mine that I've met because of my involvement in the Federalist Society more generally, and because of the involvement in this practice group in particular. And secondly, I've learned a whole bunch about the substantive area of the practice group. That you mentioned in the introduction that part of what the practice group executive committee does, probably its most important function is the organization of events, teleforums, other kinds of panels, the showcase panel or the panel that we host at the National Lawyers Convention each year. We put that together, we come up with the ideas for it, we invite the panelists, we make sure that there's ideological balance on the panel. And the process of going through that organization and just observing it, just being in the audience, being aware that these issues are being discussed, has made me much more educated about the issues that are current in free speech and election law. The panels that we put together are very much current events in the area of law. That is, we decide to put on panels based on whether the topics that are discussed are in the news and interesting to people who are following current events. So if you go to fedsoc.org and look at the page for our practice group, you will find some of the programs that we have put on recently, and you'll see how well connected they are to events that have happened in the nation in the last several months.
That's awesome. So I encourage everybody to go check that out and get involved if you can with this practice group. And there's, of course, 14 other practice groups that you can get involved in. So something for everyone and lots of good stuff going on with Federalist Society. So I wanted to transition to our topic for this evening. We're here to talk about the future of American democracy. Of course, that's perfectly fitting, being election day as it is. And specifically today, as it relates to two cases before the Supreme Court this term, we're talking about Merrill versus Milligan and Moore versus Harper. Obviously, each of these cases deals with similar but still distinct issues. Professor Dimino, would you mind taking a few minutes to briefly describe these cases and what's at issue at in each one?
Sure, of course, I'd be happy to. Merrill versus Milligan is a Voting Rights Act case, and what it does is it presents a conflict that's been kind of simmering under the surface for about the last 40 years between Section 2 of the Voting Rights Act and the constitutional prohibition on laws that deprive people of the equal protection of the laws. So first, a kind of introduction to Section 2 of the Voting Rights Act. Those of you who studied election law or who are familiar with it may know already that the Voting Rights Act not only prohibits intentional discrimination on the ground of race, but Section 2 of the Voting Rights Act also prohibits voting practices or procedures that have a discriminatory effect, that have the effect of denying one race the same opportunity to participate in the political process and elect representatives of their choice that is enjoyed by other citizens. So one of the ways that this has manifested itself is that Section 2 is generally thought of as requiring states to draw majority-minority districts when the minority race population in the state is sufficiently large and collected in a certain area of the state so that it's possible to draw a district that includes a majority of that minority group. Now, the problem with doing that is that arguably it runs up against an interpretation of the Equal Protection Clause that oftentimes is skeptical of the government's ability to take race into account in making decisions. So if we were to draw district lines and say, well, this district is for Blacks, and this district is for whites, and this district is for Hispanics, that would be struck down as unconstitutional. We wouldn't have to worry about the Voting Rights Act, or the Voting Rights Act for that would be irrelevant because the state would be violating the Constitution by creating a racial classification. And what the Supreme Court has said, starting with a case called Shaw versus Reno in the 1990s, has said that if states take race into account too much, if race is the predominant reason that a state draws electoral districts the way that it does, then the state has violated the Equal Protection Clause. Now, perhaps those of you in the audience are already seeing the conflict between that doctrine and Section 2 of the Voting Rights Act. That if Section 2 of the VRA requires states to create majority-minority districts, but the Constitution forbids states from drawing district lines with a predominant focus on race, well, then is there a constitutional problem when you create the majority-minority district that you're obligated to create under the Voting Rights Act? That's the kind of background. That's the conflict that is at somewhat below the surface of Merrill versus Milligan. Now, at the surface of the case is Alabama's congressional redistricting after the 2020 census. Alabama's population gives it 7 seats in the House of Representatives, and it has drawn district lines. The state legislature of Alabama has drawn district lines that have created 1 out of those 7 districts as majority-minority. And that is what Alabama had in the past. It had 1 out of 7. It still has 1 out of 7. But Alabama's Black population is roughly 27% of the state, which is roughly 2/7 of the state. And so plaintiffs sued and said, Blacks don't have an equal opportunity to participate in the political process and elect representatives of their choice because, among other things, they're 27% of the state's population, but they get to control the election of only 13% of the state's congressional representatives. So that's disproportionate. And although the Supreme Court has said over and over that a disproportion does not by itself mean that the Voting Rights Act has been violated, still it's relevant. And the court, the district court hearing this case, found a Section 2 violation because Alabama didn't create a second majority-minority district. Alabama's defense is, yeah, maybe we could have created a second majority-minority district, but we would have had to do so by disregarding the existing district lines totally. We would have just completely had to get rid of where the districts used to be, draw entirely different shaped districts, and we'd have to do so with an obsessive focus on race. The only way we'd be able to draw the second majority-minority district is if we made race the predominant focus of our districting, which the Shaw versus Reno line of cases says we can't do. So the Alabama is hoping that the Supreme Court sorts out the conflict between those 2 lines of cases, and I'm rather hoping that the Supreme Court makes some effort to sort out that conflict as well. The second case is Moore versus Harper. This is the so-called independent state legislature doctrine case. And it stems from a provision in the Constitution, Article 1, Section 4, Clause 1, that says that the times, places, and manner of federal elections shall be determined in each state by the legislature thereof. That's the key phrase, in each state by the legislature thereof. What happened in North Carolina, again, after the recent census that necessitated redistricting, was that the North Carolina legislature, which is controlled by Republicans, drew districts that were favorable to Republicans. The districts were challenged in state court, and the claim was that those districts violated the state constitution. State constitution protects a right to fair elections. And the North Carolina Supreme Court, which is not controlled by Republicans, interpreted that state constitution as prohibiting partisan gerrymandering, or at least prohibiting excessive amounts of partisan gerrymandering. So the North Carolina Supreme Court strikes down the redistricting as a violation of the state constitution. And that's what's led to this lawsuit, because the state legislature says, if you allow the state court applying the state constitution to stand in the way of the legislatively chosen map, then it's not a map that's been chosen in each state by the legislature thereof. The legislature of North Carolina chose a map, and that map can't go into effect because there's some other institution of state government, the courts, using the state constitution that's standing in the way. This is why we call it the independent state legislature doctrine. It's the idea that when the Constitution of the United States says that the times, places, and manner of federal elections shall be determined in each state by the legislature thereof, it means that the legislature gets to act independently of the state courts, and at least to some extent, independently of the state constitution. Because if the state constitution contains this right against partisan gerrymandering, the claim is in this case that the state legislature's gerrymandered maps should prevail anyway. Now, against that interpretation is the thought, well, a couple of different arguments. Number one is an argument based in precedent. The Supreme Court considered a case a few years ago out of Arizona that allowed an independent redistricting commission to draw congressional districts, even though the Constitution says that the manner of federal elections shall be determined in each state by the legislature thereof. The Supreme Court said that legislature doesn't necessarily mean the institutional legislature, the state version of the House and Senate. It can mean the lawmaking body of the state, and if this independent commission has legislative power, then it can act as the legislature. So the thought is that if that was okay, if legislature in the Constitution doesn't really mean the institutional legislature, well, then that presents a kind of problem for people arguing for the independent state legislature doctrine. The other series of arguments against this doctrine is, do we really want these legislatures to be able to act independently of state constitutions? If state legislatures usually establish districts through legislation, well, the usual practice is that they pass a law or they pass a bill establishing these district lines, and then they send it to the governor, and the governor may veto the districting law. Well, if we really believe in the independent state legislature doctrine, then perhaps we should think the governor should play no role in the process. But the Supreme Court many decades ago said that's okay, that the governor can play a role. So we don't really mean that the legislature gets to act independently of all restrictions in the state constitution. If the state constitution says you can't pass a law without going through the governor first, well, then we can enforce that provision. So why wouldn't we be able to enforce a provision in the state constitution that says when you pass one of these laws, it can't be too much of a partisan gerrymander? And against all of that is the textualist argument that the Constitution doesn't just say that the times, places, and manner of federal elections shall be determined in each state or in each state by law. It goes out of its way, seemingly, to say the times, places, and manner of federal elections shall be determined in each state by the legislature thereof. And so people who support the independent state legislature doctrine say that if you don't rule for the North Carolina legislature here, aren't you basically reading those words of the Constitution out of the document? You're reading it as if the Constitution didn't say by the legislature. And that's the issue involved in that case. Thank you for giving me the opportunity to summarize both of those.
Yes, thank you for doing that. Just real quick before I move on to a couple of my questions, for anybody in the audience If you have a question before we end tonight, we'll hopefully have a time for 1 or 2 questions from y'all. So if you want to use the Q&A feature down at the bottom and submit a question for Professor Dimino, that would be really great. And hopefully we can get to 1 or 2 of those before we end tonight. So I have a question for you. So kind of along the lines of everything you've kind of already said, ultimately what's at stake in these 2 cases, depending on how the court decides them? So what would it look like moving forward, depending on what they decide?
In politics or in political election law cases, it can be hard to predict. In part, it's always hard to predict what the result's going to be from these cases. I think it's especially hard in political cases because the rhetoric surrounding them tends to be overheated. So there have been some people who suggest that if the court agrees with the independent state legislature doctrine, that the results could be pretty severe, in that we might have state legislatures that refuse to accept results of elections and change. The first step would be that it would make partisan gerrymandering much easier, that the state constitutions and state courts that have tried to rein in partisan gerrymandering would be unable to do so, at least in federal elections, and that might make the partisan districting process worse. There's also a potential implication because of the similarity of language in the Constitution's provision that I've quoted when it's compared to the electoral college language, because the electoral college, the manner for choosing electors also is determined in each state by the legislature of the state, that if we buy into the independent state legislature doctrine, perhaps there could be some kind of crisis that would manifest itself if there was some concern about some controversy surrounding a presidential election. That's certainly a possibility, but whether it manifests itself into some kind of crisis, I think it's difficult to determine whether it will or not. As to the other case, the implications of that also hard to predict with certainty, but on the one hand, if the plaintiffs win, so if the challengers to the district win, then I don't think too much will change right away, because the prevailing interpretation of Section 2 of the Voting Rights Act does require the creation of majority-minority districts, and would more or less results in the drawing of a proportionate number of majority-minority districts if the minority groups are clustered in the state in a way that makes it easy to draw districts around them. And I don't think too much would change from that if they won. The negative that would happen if they did win would be that the court's commitment to a race-neutral districting process would be watered down. It would be much harder for the court to, well, it would be somewhat harder for the court to say that you have to downplay race if we say, in the context of this case, you're supposed to downplay race, but you really have to consider race an awful lot in order to draw this second majority-minority district. On the other hand, if Alabama wins, then a lot's going to depend on the rationale that the court uses in its opinion. Because if the court says that Alabama wins because you should not, or maybe you're constitutionally forbidden from considering race to the extent that you need to draw this second district, well, then that has the capability of I guess you could call it watering down Section 2 a bit, and making it much less likely that we'd read Section 2 to require states to create those majority-minority districts. And what you might have is, you might have fewer minority representatives in Congress. You might have minority communities that don't find it as easy to control the election of a certain representative. And that could be, it has obvious negative implications in terms of the ability to represent those groups. But majority minority districts also tend to produce some of the more extreme and polarizing members of Congress. And so to the extent we have this national desire to make race an irrelevancy, then if the court were to come out and say, we're really suspicious of your consideration of race, we don't want you to bend over backwards to include consideration of it as much as you can, well, then maybe we'll end up with more homogeneous districts, more representatives that feel the need to cater to the interests, not just of the minority community, but to others as well. So maybe more moderate, more consensus kind of people could be selected from those districts. So that's to some degree speculation, but is at least a possible result depending on which way these cases come out.
Thank you for that. Briefly going through some of the questions we've got here. Thank you all for submitting questions. I know we're running a little short on time, and I'll try to get to at least one of them. So I've got a question from Steve. He asks, Professor, any thoughts on why so little attention as to how the court might resolve more according to the well-settled criteria for resolving cases under the third prong of 28 U.S.C. 1257A cases, where the state court is accused of an unsupportable decision rather than the new ISL theory? Did that make sense?
Well, let me say at least what I think the question might be getting at. So if some of you will remember when Bush versus Gore was decided in 2000, part of Chief Justice Rehnquist's decision, he wrote a concurrence in the case, and part of the rationale of his concurrence was that the Florida Supreme Court had overtaken the Florida legislature's responsibility because the Florida Supreme Court had so badly interpreted the Florida statute that the court was making up the rules instead of having the legislature make up the rules. And I think that's what the question means when it refers to an unsupportable decision. The problem with applying that to Moore, at least as I understand it, is that it's not that the North Carolina decision below was not unsupportable, in that it was an interpretation of the North Carolina Constitution. And the North Carolina Constitution was certainly vague. It didn't say anything about partisan gerrymandering. It just refers to fair elections. But courts, including the US Supreme Court, of course, have interpreted rather vague provisions in a manner that might be surprising to someone who's an outsider. So you might say, well, the First Amendment of the US Constitution just says freedom of speech. How do we get this doctrine out of, how do you get some campaign finance doctrine out of free speech? Well, here's what it is. And it's the North Carolina's Supreme Court's interpretation of the North Carolina Constitution is kind of similar in that respect. Yes, it's vague. Yes, it's general, but the courts often take a general provision and put a kind of specific gloss on it. And I think that the US Supreme Court would be awfully nervous about saying that there's something wrong when a court does that, given how the US Supreme Court has done it in so many of its own aspects of constitutional law.
All right. Well, thank you, Professor Dimino. I see that we are short on time, so I just wanted to thank you again for joining us this evening, and to everyone who decided to join us tonight. I hope you all will join us next Tuesday. There will be another FedSoc study break next Tuesday at 8 p.m. Eastern. The title is Religious Liberty on Campus and Beyond, Reflections on Law and Practice. And that event will be co-hosted by the Albany Law School Federalist Society chapter. So I hope you'll be there for that. I know that'll be another great event. Again, thank you, Professor Dimino, and to the Federalist Society for for putting this event on for us this evening. So thank you all for joining us.
Thank you.